हेलो फ्रेंड्स, वेलकम टू अवर यूट्यूब चैनल धनराज शॉर्टहैंड एकेडमी स्टेनो क्लासेस। दोस्तों, आज का हमारा डिक्टेशन है हाई कोर्ट लीगल डिक्टेशंस जीटी बेस्ड लीगल डिक्टेशन एट द स्पीड ऑफ 80 वर्ड्स पर मिनट। डिक्टेशन स्टार्ट विद इन 5 सेकेंड। Start from the perusal of the records and the submissions of the parties. We observe that the mandate of the arbitrator was extended by an agreement between the parties. Thus, it can be constructed that the parties had not agreed to the extension of the mandate of the arbitrator, following which the mandate was automatically terminated. However, the contention of the appellant that the High Court had erred in not allowing the appellant to decide upon the appointment of an arbitrator pursuant to subsection within bracket 2 of section 15 of the act must be accepted. Stop. In this connection, it would be appropriate to refer to the relevant portion of the impugned judgment of the High Court, which gives an elaborate observations on the above mentioned issue raised by the appellant. Arbitration is an informal, quick and easy alternative mode of adjunction of disputes by agreement of the parties. This court clause was invoked way back in May 1996 and almost 10 years have expired since then. The appointment of successive arbitrator by the chairman cum managing director of the respondent has only resulted in delay. When the mandate of an arbitrator is terminated on the ground of delay, the rules applicable to the appointment of the arbitrator are to apply to the appointment of a new arbitrator. It would, however, be a mockery of justice if every time the mandate of an arbitrator was terminated or the arbitrated resigned or otherwise became unable to proceed, the parties were to start from scratch by invoking the arbitration clause para. Once the mandate of the arbitrator terminates, the person required to appoint arbitrator is required to fill up the vacancy with utmost expedition, following which the provision of section 11 within bracket 6 of the 1996 act would be attracted. In the instant case, as per the arbitration agreement, the chairman cum managing director was required to appoint a new arbitrator in case the arbitrator became unable to continue, whatever be the reason. Para. A bare reading of the scheme of section 11 shows that the emphasis is on the terms of the agreement being adhered to and or given effect as closely as possible. Stop. In the other words, the court may ask to do what has not been done. The court must first ensure that the remedies provided for are exhausted, it is not mandatory for the Chief Justice to appoint the arbitrator para. In all these cases at hand, the High Court does not appear to have focused on the requirement to have due regard to the qualifications required by the agreement or other considerations necessary to secure the appointment of an independent and impartial arbitrator. It needs to retrition the appointment of the arbitrator or arbitrators named in the arbitration agreement is not a must, but while making appointment, the twin requirement of subsection within bracket 8 of section 11 have to be kept in view, considered and taken into account. Stop. If is not done, the appointment becomes vulnerable in the circumstances. We set aside the appointment made in each case, remit the matters to the High Court to make fresh appointment, keeping in view the parameters indicate above para. In the aforesaid decision of the case of Northern Railways Administration held that the High Court in the said case did not appear to have focused on the requirement to have due regard to the qualification required by the agreement or other conditions necessary to secure the appointment of an independent and impartial arbitrator. Stop. In the aforesaid decision, this court also concluded that since the requirement of subsection within bracket 8 of section 11 was not at all dealt with by the High Court in its order, the appointment of an arbitrator without dealing with subsection 8 of section 11 of the Act became vulnerable, and accordingly such appointment must be set aside. Similar is the position in this case. In this case also, before appointing an arbitrator under section 11 within bracket 6 or the Act, the High Court had failed to take into consideration the efforts of section 11 within bracket 8 of the Act, as was done in Northern Railway Administration para. In view of the discussion made here and above, and particularly in view of the principles laid down by this court in Northern Railway Administration, we set aside the impugned order and remand the case back to the High Court for fresh decision of the application under section 11 within bracket 6 of the Act, and while considering the application afresh, the High Court is directed to take into consideration the aforesaid decision of this court. It is clear from the perusal of the judgment of the High Court and the records before us that the High Court had not terminated the mandate on the ground that the arbitrator could not pass the award within time stop. आई होप आप सभी को डिक्टेशन पसंद आई होगी, तो प्लीज़ कमेंट बॉक्स में कमेंट करें और अपने अभी तक चैनल को सब्सक्राइब नहीं किया सब्सक्राइब करें और वीडियो को लाइक और शेयर करना ना भूलें। थैंक यू।